Hey everyone, so it's me, Leonard French, with an update on the voter suppression thing. I've received an email from my election office saying, I'm very sorry this is happening. Please be assured this was not initiated by this office or the election board. If you are unable to attend the hearing on Friday, please write me something you wish to address to the board. I will make sure that every one of your voices is heard. This article addresses the issue throughout the state. Again, I'm very sorry I can't answer for the Board of Elections, but I believe the challenge to be a frivolous challenge based on nothing. The basis of this challenge is contradictory to federal law. I think it's just noise. And then I received something from the ACLU with more information about reporting my situation to them and then keeping track of their response as well. So they've got a link to a PDF document as well that I'd like to go over with you. It says, to all county solicitors, on Friday we learned that at least 9 counties in Pennsylvania received mass-produced challenges to the eligibility of qualified overseas voters who applied for and were approved for absentee ballots in the 2024 election. These mass challenges, which purport to proceed under the election code provision relating to challenges to mail ballot applications, assert that the challenged voters should not be allowed to vote because they are outside the United States and are not registered to vote in Pennsylvania. Nearly 50 years ago, Congress enshrined overseas U.S. citizens' continued right to vote in the district where they last lived, but only for federal elections. Consequently, county boards of elections legally must allow the challenged voters to cast ballots for federal officers in the upcoming election. The challengers either misunderstand or ignore this long-standing federal law. Either way, the law requires that these challenges be summarily denied. The challenged voters are U.S. citizens now living abroad whose last U.S. residence was in Pennsylvania. These individuals are entitled to vote in federal elections under the Federal Uniformed and Overseas Citizens Absentee Voting Act, UOCAVA, which President Reagan signed into law in 1986. This is the 20302 law that I showed you in the previous video. UOCAVA authorizes these federal voters to vote in the district in which they last lived in the Commonwealth, but only for federal elections: President, U.S. Senator, and U.S. Representative. While these voters may not be technically registered to vote in Pennsylvania for purposes of state elections, federal law indisputably protects their right to vote for federal offices. Here, the challengers appear to have simply mass-produced and batch-submitted challenges to all or virtually all of these federal voters in certain counties. In addition to being legally deficient, mass-produced challenges like these are not a proper use of the election code's absentee ballot application challenge provisions because they are not based on individualized information about the voter known personally to the challenger. The challenge process, which can require boards of elections to expend precious public resources during the height of the election season, is not an appropriate means for the challengers to simply register their disagreement with the clear requirements of federal law. We caution that taking any action to prevent these federal voters' ballots from being opened and counted in federal elections based on such mass challenges would be unlawful. The challenged voters are qualified overseas voters within the meaning of the law, and federal law provides that election officials must allow such overseas voters to vote by absentee ballot in general, special, primary, and runoff elections for federal office. Pennsylvania Department of State guidance also sets forth the process by which these federal law requirements are carried out by the county boards of elections. There's a link. The proper course of action for any county receiving mass challenges to these federally qualified overseas voters is to summarily reject the challenges as both procedurally and substantively deficient. Counties should formally dismiss or deny the challenges as quickly as possible to minimize any delay or disruption to the canvassing process. If your county has received these mass challenges, we would appreciate it if you could let us know at the email address provided at the end of this letter. At a minimum, we ask you to advise the Department of State of your receipt of such challenges. So I guess I'll be doing that next after I get this done. A more detailed analysis follows. If you have any questions about this issue, please do not hesitate to contact us. And then they have another 4 pages of mass voter challenges and how they are legally deficient. So if you'd like to stop there, you could be forgiven. If you'd like to continue, here's More analysis. Beginning on or about November 1st, less than a week before the November 2024 general election, a few Pennsylvania residents began batch filing thousands of cookie-cutter mass challenges to certain absentee voters. The challenged voters are U.S. citizens who now live abroad and whose last domestic residence was Pennsylvania. These voters have requested an absentee ballot to vote for federal offices. They affirmed as part of their application process that their last U.S. residence was Pennsylvania. They now live abroad, and their intent to return is uncertain, and they otherwise meet the qualifications to vote under state law, such as age and citizenship. Each county board where these citizens last lived approved their application based on a determination that they were in fact so qualified. As of the date of this letter, November 3rd, we are aware of over 3,000 of these challenges being batch submitted to officials across at least 9 counties. These challenges to UOCAVA federal voters are, in addition to and different from, the improper mass challenges to domestic, civilian, and military family mail ballot voters that we wrote to you about on October 28th. Those are based on a voter's filing of a change of address form with the U.S. Postal Service. A review of the recent challenges to federal voters in several of the affected counties reveals that the challenges are identical in format and content except for the voter's name and personal information. The challenges appear to have been mass-produced from a database using a mail merge function. Each asserts that the challenged voter is not eligible because the voter allegedly indicated on their ballot application that they are currently and indefinitely out of the country and are not a member of the military and not registered to vote, and therefore not eligible to vote in Pennsylvania. The challenges appear to proceed based solely on information from a database, and the challengers do not purport to personally know any of the challenged voters. These challenges are fatally flawed under federal law and should be rejected. The federal UOCAVA and its predecessor statute have for decades guaranteed that U.S. citizens living abroad, like the challenged voters, may vote in federal elections. The UOCAVA's protections apply to overseas voters, whom the statute defines as an absent uniformed services voter, a person who resides outside of the United States and is qualified to vote in the last place in which the person was domiciled before leaving, or a person who resides outside the United States and, but for such residence, would be qualified to vote in the last place they were domiciled before leaving the United States. That's Section 20310, subsection 5. UOCAVA guarantees that U.S. citizens who come within this definition of overseas voters may vote in federal elections. Under UOCAVA, states shall permit overseas voters to use absentee registration procedures to vote by absentee ballot in general for special primary and runoff elections for federal office. In other words, a UOCAVA-protected overseas voter, as defined, must be permitted to vote by absentee ballot in federal elections. The first 2 categories of protected overseas voters are also able to register and vote in Pennsylvania elections, pursuant to Pennsylvania's Uniform Military and Overseas Voters Act, the UMOVA. These categories of voters come within the definition of covered voter there, and accordingly they may register in Pennsylvania and also vote by mail ballot in state elections. The third category of overseas voters who appear to be the citizens challenged here are the so-called federal voters. These U.S. citizens' last residence was in Pennsylvania before they moved abroad, and they are uncertain whether they might return to Pennsylvania. Because they currently reside abroad and their intent to return is uncertain, these voters are not covered by UMOVA, the state law, and cannot register and vote in elections for state offices. However, because but for such a residence abroad, these voters would be qualified for where they lived before leaving the United States, so my old address. They are qualified overseas voters under UOCAVA. Accordingly, they must be permitted to vote by absentee ballot for federal offices in the districts where they previously lived. Congress first extended federal voting rights to this group of U.S. citizens in the Overseas Voting Rights Act of 1975, and the courts have acknowledged and affirmed these federal law provisions extending federal voting rights to voters who may not otherwise meet state residency requirements. The Pennsylvania Department of State maintains current guidance on UOCAVA federal voters, which, consistent with federal law, provides that while such federal voters need not and cannot meet Pennsylvania residency requirements, they may still cast a vote for federal offices as a federal voter under UOCAVA. This is the case even though UOCAVA federal voters formally may not register to vote under state law due to the residency requirement. Federal law still requires that qualified federal voters be permitted to vote for federal offices. Any attempt to exclude or prevent the counting of votes for federal offices cast by these voters based on current residency or failure to register is thus directly contrary to federal law. These U.S. citizens are specifically authorized to vote for federal offices, notwithstanding their residency abroad or registration status. Besides the foregoing fatal legal deficiency, these challenges are also deficient procedurally. The only valid basis for a challenge to an absentee or mail ballot application is that the applicant is not qualified. The burden of proof to demonstrate that the challenged voter is not qualified is on the challenger. Challenges should be brought by individual electors based on individualized information about particular circumstances personally known to the challenger that render the challenged voter actually ineligible. Mass-generated challenges such as these are prima facie, or on their face, insufficient and should be summarily rejected. They are not based on the challenger's personal knowledge about the voter. They do not assert that the challenged UOCAVA federal voters do not meet any of the qualifications to vote other than residency, nor do they make any individualized assertions about the voters that might call their prior residence in Pennsylvania into doubt. Rather, these challenges appear to have been produced en masse using the SURE system or some other voter database in which UOCAVA federal voters are coded into a specific federal unregistered code. Again, federal law specifically requires that U.S. citizens living abroad be permitted to vote by absentee ballot in federal elections in their last home state, whether or not they are registered or may become registered, so long as they would be qualified to vote there but for their residence. Challenging these voters based purely on their status as UOCAVA federal voters is not an appropriate use of the challenge process. The challengers may disagree with Congress's determination to extend federal voting rights to these U.S. citizens, and with the last 5 decades of unbroken compliance with the federal law across the nation on this point. If so, they should contact their representatives in Congress. It is not proper for them to direct their disagreement to the county boards of elections and to waste public resources by filing legally baseless mass challenges in defiance of federal law. Accordingly, these mass-generated challenges are facially insufficient to show that these voters are not qualified to receive an absentee ballot in order to exercise their right to vote for federal offices as guaranteed by UOCAVA. One other point bears mention for county boards of elections and other officials considering whether to grant these challenges. Voters can enforce the rights guaranteed in UOCAVA in federal court, including under 42 U.S.C. 1983, which permits the award of attorney's fees to prevailing plaintiffs. Any actions by the boards of elections with respect to these election eve mass-generated challenges to UOCAVA federal voters, other than the swift rejection or dismissal of these challenges, will violate federal and state law. We ask that the challenges be swiftly rejected or dismissed so as to avoid unnecessary litigation and expense. Any indication that a county intends to pursue some other course will be treated as an imminent violation of law and the rights of protected voters. We would also greatly appreciate it if you would immediately inform us if you receive any challenges of the nature described above. If you intend to process any such challenges, we ask that you provide the list of voters who are being challenged and the dates of any hearings. At a minimum, we strongly encourage you to notify the Pennsylvania Department of State. Please do not hesitate to contact us if you have any questions. You may contact us directly at vote@aclupa.org. That's by Witold Walczak and Ari Savitsky, legal director and senior staff attorneys at ACLU, PA, and ACLU headquarters, I guess. So yeah, that's what's happening right now. My next step, I guess, is I'm going to write to the Pennsylvania Department of State and make sure that I'm assuming my election office has already received this letter, but yeah, that confirms to me that I probably do have a Voting Rights Act or Civil Rights Act claim, and I'm going to start preparing how I will file that and pursue that. Let me know what you think in the comments below. I'll keep you updated. Love you all. Bye.